Scott versus Stanford, 1857. Dred Scott was born and enslaved in Virginia, bought by Dr. Emerson, a military surgeon. In 1833, Dr. Emerson died and Dred Scott tried to buy his freedom, but they would not let him because he was an African descendant, which did not have the right to vote or sue. 4 years of war and the adoption of the 13th, 14th, and 15th Amendment to let him become a free man. He became a free man in 1857 when his former family bought his freedom. Sadly, he died 9 months later of tuberculosis. Gideon versus Wainwright, 1963. In 1963, Gideon was charged with breaking into a Florida pool hall, stealing beverages and $5 in cash. When Gideon went to court, he claimed he could not afford a lawyer, and he asked for one in court. When the court did not give him one, he was charged guilty of the crime. After Gideon was charged with the crime and in jail, he pleaded the Sixth Amendment, which he argued guaranteed him the right to a lawyer. Later, Gideon went back to court, and after he got his lawyer, he was charged not guilty of the crime he was charged for. Because of this case, states must now give free lawyers to criminal defendants that cannot afford one. Marbury versus Madison, 1803. In 1800, President John Adams lost to Thomas Jefferson in re-election. During Adams' last week in office, he sent a bunch of people to be justices of the peace in the District of Columbia. The men were not sent when John Adams was in office, so when President Jefferson took over, he refused to send them. William Marbury, who was appointed and did not go, was upset, so he went to the U.S. Supreme Court to ask for a writ of mandamus. William Marbury argued that he was entitled to the writ because he had a commission already created. The Supreme Court agreed that Marbury had the right to the writ, but disagreed that the Supreme Court can write it. Only certain cases can start at the Supreme Court. One of the biggest cases, and the fact that the Supreme Court had to decide what was constitutional is called a judicial review. Miranda versus Arizona, 1966. In 1966, Ernesto Miranda was arrested for a violent crime in Phoenix, Arizona. Later, he was taken into an interrogation room for 2 hours, and the police came out with a signed confession with Miranda claiming that he knew his rights listed in the Constitution, but in fact he was not told of those rights. After the cops pulled the signed confession in court, Miranda confessed that he did not voluntarily write that because he was not told of his rights. He argued that since he was not told his rights, they should not have used the confession in court, and because of this case, the famous Miranda warning came out. In Regal, 1967. In 1967, an Arizona sheriff arrested a 15-year-old boy, Gerald Galt, because a woman complained about him and another boy making an indecent phone call. At the station, they told the mom of Gerald Galt there would be a hearing, and then nobody showed up, not even the woman that complained. Then later, they told her there would be a second hearing after they held him in for a day. Then nobody showed up to that second hearing. Since nobody showed up to both hearings, he had to testify at both of them, and he was convicted with the crime. Since they took his liberty without the due process of law, the Supreme Court agreed, and now it should apply to juveniles as well as adults. This is Nixon, 1974. President Nixon wanted to win re-election badly in 1972, so badly that he put a wiretap in the office. President Nixon's campaign put a wiretap in his opponent's office. At 2:30 a.m., 5 men were seen placing a wiretap into the Democratic Party's office, which is Nixon's opponent. After Nixon went to court, he did not turn in the evidence after the judge told him to, which is the recordings. He said, since the executive branch and the judicial branch are separate branches, they do not have the power to do that, and they might be able to do it to regular citizens, but not the president. Although in some cases the president's recording may not be able to be used because they might have information that is sensitive and can put the nation's safety in risk, Nixon never claimed that his recordings had sensitive information. Hazelwood School District, versus Kohlmeyer, 1988. In 1983, Hazelwood School District were writing newspapers for Journalism 2 class about teen pregnancy and how divorce impacts. So after the principal read the newspapers before publishing them, he took them down because he thought they were inappropriate. So then one of the boys, Kohlmeyer, argued that this was invading their First Amendment, their rights, which is the freedom of speech, press, religion, assembly, and petition. So, after this, the court agreed with the principal, or ruled in the principal's favor in a 7-2 vote, that the school can control what students say if it's inappropriate or isn't related to the basic learning instructions. This case changed how parents and students view their freedom of speech, press, religion, petition, and assembly work in schools. In 1950 and 1951, parents and black students fought in states against schools that only allowed white kids in. The states tried to make the school equal, but Brown and others argued that separating white and black people cannot make it equal, showing that black people are inferior. Therefore, separating black students and white students violates the 14th Amendment, which is equal protection under the law. Because of this, schools can no longer reject black students in white schools only. Even though this was primarily for K through 12 schools, it now applies to colleges and universities.